Hello, this is Mary Mack, and I'm very pleased to introduce you to our ZyLAB webinar, which is preparing for the General Data Protection Regulation, the GDPR. We'll be talking about critical technology in the era of the GDPR today. We have two wonderful presenters. Johannes Scholtes, Chief Strategy Officer and founder of ZyLAB. Jan, before joining ZyLAB, Jan was a lieutenant in the intelligence department of the Royal Dutch Navy. He holds a Master of Science degree in computer science from Delft and a PhD in computational linguistics from the University of Amsterdam. And as of 2008, he holds the extraordinary chair in text mining from the Department of Knowledge Engineering at the University of Maastricht. Our other presenter is Machteld Hiemstra. She is counsel with Simmons Simmons, and she is specializing in civil, commercial, and regulatory law, an experienced litigator, and she regularly advises clients on data protection legislation and the implementation in the EU. She has specific expertise in IP, pharmaceutical, medical device law, data protection, and telecommunications. And so we will be talking about the changes that have gone on in the EU. Our agenda is why the protection is needed, why automation is needed. At the end of our session today, Jan will show some
Yeah, so I will be talking about the data protection regulation, and in the first slide, Mary, if you could do next slide. Mary, if you could do next slide.
Now I can.
Yes.
Thank you.
Slide one again. 2, 3.
There we go.
There we go.
I think we're connected. Yes, we are connected.
So I want to talk about the introduction of the data protection regulation, which will become into effect only on 25th of May 2018, but there may be a lot of work depending on the jurisdictions in which you are. Just some differences between what we have in place now, which is the Data Protection Directive, which sets minimum standards only and which requires national member states to impose those minimum standards into national law, as a result of which there is a wide variety of set of regulations that may be applicable in different member states. This also means that sometimes you have a battle between member states of who has the strictest or less strictest regulation with regard to data privacy. Now, the General Data Protection Regulation introduces a regulation which means that it is directly applicable in all member states, and as a result of this, it facilitates that all EU citizens have equal rights. The idea is that there is full harmonization instead of a legal patchwork as we now have, but I will talk later about the exceptions under the General Protection Regulation. Still, it's an improvement contrast to what we have. Moving to the next slide about the territorial application. The GDPR will apply to organizations which have an establishment in the EU where personal data are being processed in the context of activities. And the test used to be that the data processing should take place in the EU, so the territorial scope is much wider. Furthermore, the regulation will also extend to non-EU based companies with no establishment in the EU who are offering goods or services who are monitoring. And it will furthermore apply many obligations directly to data processors rather than to data controllers. And this means that you can have a data controller in one country and a data processor in another, and they both have to apply the same rules. Next slide, Mary. Thank you. I'm now going to talk about data governance, and this means that you have to ensure data protection. There are a list of obligations that need to be fulfilled, and to maintain records of all processing activities is a very important one. This is a new one. The recording activities include the purposes of the processing, a description of the categories of data that you're processing, also of the recipients, including recipients in third countries. It says where possible the time limits for erasure, but actually you need to include a retention period, and also a description of the technical and organizational security measures that you take to protect the interests of data subjects. Furthermore, you have to provide justification grounds, because justification grounds for the processing, and if you rely on consent, you have to be able to show proof, which you should also record. There is a small exception if you have a company with less than 250 people. There is and no data processing takes place on a regular basis. You don't have to comply with this, but this is really a theoretical exception in most situations. There's also an obligation to appoint a data protection officer, which is now not mandatory. And that is if the core activities consist of processing operations which require regular and systematic monitoring of data subjects on a large scale. Now, it's not undefined what a large scale is, but in many situations where you have where you have data processing activities, it is very likely that you will qualify as a company for this obligation. The other concept in relation to data governance is privacy by design and privacy by default, which means the implementation of measures showing that a company has considered and has adopted compliance measures in view of their data processing activities. So this may be quite different depending on the sort of data you're processing and the sort of business that you're in, which is why it's privacy by design. Next slide, please, Mary. Another important element of the new GDPR is the privacy impact assessment and notifications. Under the current legislative regime, you will have to do notifications. In some countries it's mandatory, in other member states it's not mandatory. But instead of these notifications, you can do a privacy impact assessment. And it is mandatory where a type of processing is likely to result in high risk to the rights and freedoms of natural persons. Again, this is not very defined and will need to be further developed. It needs to be done prior to the processing, and if high risks are established, you need to notify the regulatory body, which has to be done to the lead supervising authority. And the lead supervising authority, we'll speak about that later, but that is the authority in which the data controller has its seat in the EU. A PIA, just to say something about a PIA, what must it include? It's not on the sheet, but I thought it would be interesting to tell. It should include a description of processing activities and the purposes, and it should include an assessment of the need for these activities and the proportionality of the activities. And if a DPO, so data privacy officer, was appointed, it would also need to include an advice given by the DPO how to mitigate risks involved in the data processing activities. Moving on to the next slide, the data breach. This is a very, very important new legislative requirement because it requires company to potentially inform subjects, data subjects, if a data breach occurs. And the Netherlands is the only country in which the data breach notification obligation already exists. Just to tell what a data breach is, it's very wide. It's any accidental or unlawful processing, which includes a loss, alteration, disclosure, transfer, access, anything which constitutes an unlawful access to data. This can be an intercompany access, so staff who should not be in the neighborhood of certain data, or third parties. And examples of a data breach are obviously a data hack, but it could also be losing a USB stick including information, or just a file being left in the train. If you have such an incident, you have the obligation to notify the supervising authority of the data breach, which is set without undue delay, and where feasible not later than 72 hours. If it takes longer, then you need to explain why it takes longer. There are also some minimum specifications that need to be put in the notification, which is the nature of the personal data breach, data categories, and also the number of data subjects affected. The obligation to notify data subjects of the data breach is very new, but there is a big exception to this rule, and that is if there is a low probability of risk to the rights of freedom and of the data subject. Now, this is obviously something that needs to be assessed on a case-by-case basis, and probably also in consultation with the data protection authority in the country where you have the notification obligation. In order to be able to demonstrate that companies comply with the law, you need to have a data breach protocol, which basically means a protocol saying what will happen if you have a data breach, in which you could also describe the risks for a data breach, the people responsible, who will be the first contact in relation to the data protection authority, those kind of things. And you would also need to be able to provide a description of the technical and organizational measures showing how you try to prevent data breaches, and that may be relevant should it come to sanctioning. Another thing in relation to data breach is that parties should consider data processors or intercompany entities and the duty to inform. Because if you don't get information from your data processors or from intercompanies where the data breach may have occurred, then you cannot fulfill the obligation to notify. So that's very important to bear that in mind. Another thing is, and that's not in the law, but it's more practical implication, you should not just consider the actual data breaches, but also the threats of a data breach, because that may prevent further actual incidents. Moving to the next slide, Mary. A slide on data subjects' rights. I think a lot of attention was drawn to it. The data subjects are given various rights already under the current data protection law, which is data, right to require a controller to rectify or block or erase or destroy personal data, and a right to claim compensation for damage resulting of infringement. Now, I should say that a right to compensation for damages is in most countries already embedded in the civil legislation, but just in case it wasn't, the GDPR makes clear that data subjects have a right to compensation. The currently existing rights are extended under the regulation, and it used to be called the right to be forgotten, which is now the right to erasure, because, well, for practical reason, nobody can be forgotten, and it's only about erasure, which is where data controller has published data, reasonable steps to inform third parties that data subject has requested erasure. And I should say that this right is not unrestricted. If the data controller still has a purpose for processing, then they should be able to say, well, we cannot fulfill this requirement now because we have to, I don't know, complete a transaction or a contract, or we need to have it in store for legal reasons to comply with laws, or within the context of litigation to defend yourself in a claim. However, if the purpose for processing does not longer exist, the right for erasure should be met. There's also right to data portability, which is the right to receive personal data and to provide it in a structured and commonly used manner, which allows the data subject to take his data and to bring it to another data controller. It's also important to note that there is a right to claim damages, which was introduced from the controller or the processor, which is joined to several liability. And this is a very important new right, because it used to be the situation that only the controller was the responsible party in relation to the data subject. This means for processors that they have to consider whether they need insurance, and they also need to consider their contractual clauses in data processing agreements. I will talk about that later. I was just forgetting one other very important exclusion to the right to erasure, which is the freedom of expression, which basically means journalism, and also public health, and of course national safety. Those are the most important exclusions to the right to erasure. Moving on to the next slide, thank you, which is about the lead supervisory authority, which is posed as a one-stop shop. The supervisory authority of the member states in which the controller has its main establishment is going to be the leading supervising authority, and the main establishment is to be determined on the basis of the criteria that I put on this slide, which is where the effective and real exercise of management activities take place. And it does not depend on whether the processing of personal data is carried out at that location. It is where the decisions are being taken. That is basically what it boils down to. The lead supervisory authority is the first contact for the data controller, and they are basically responsible for enforcement and applying fines. And this is an important, in practice this will become important because the lead supervisory authority decides on the basis of national law what a maximum fine can be. So if you look at the GDPR, you will see that the fines can be up to 10 million or 20 million, but in most countries it's much lower. They also decide whether or not to bring, to involve criminal law. And other things that should be considered is how they operate. So in the Netherlands, for instance, if there is a non-compliance issue, then you will get a warning first before there will be an administrative penalty. That is the way to do things. But in other countries, you may have a penalty immediately or a fine, and then discussion with the authority whether or not that was correct. So that gives a totally different starting point in discussions. There are some exclusions. If the national authority remains competent in case of a complaint which, and then the wording is substantially affects a data subject only in that state, or if it relates to an establishment in that state only. And that makes of course sense because there is no reason for another authority to be involved if they don't have any direct, if there are no direct consequences in that member state. I'm going to move further to fines, which is the next slide. Yeah, thank you. Like I said, the fines are quite high, but the GDPR sets maximum standards. There is currently a high degree of variation between the maximum fines that can be applied or imposed, and it would seem that this will remain in place. There are two categories of fines, and I've listed them predominantly on the sheet. Notification of a personal data breach is considered very important. Still, it's not subject to the highest fines. That's interesting. well, I think it's important for companies to understand that fines are going to be increasingly used and applied, also because the fines at present are very low. And again, to give you an example for the Netherlands, the fine for violation of the Data Protection Act used to be 4,500 euros, and fines are now usually around 20,000. And not too long ago, a company received a fine in relation to a data breach for 450,000 euros. So this is going to be, this must be taken seriously. Moving on to the next slide. There are some general conditions for imposing fines which are also determinative for eventually the height of the fine. And I've listed those on the slide: nature, gravity and duration, and also, this is an important one, degree of responsibility of controller or processor. Degree of responsibility is, I mean, if you're acting intentionally, then in most countries you will move to a criminal offense. But degree of responsibility has to do with the measures that you have been putting in place to protect data from infringements, or the actions that you've taken to make sure that you do not violate any of the GDPR requirements. For instance, providing sufficient information, being transparent, and all other things that you have to do in relation to data subjects so that they know what you're doing with their data and for what reasons. I can move on to the next slide. I have this slide just gives you an impression of important considerations for transferring data to group companies or third parties. And the things that you should consider roughly, which is the security of data. And this is very often forgotten because companies think that they have their own security system in place, and then they transfer it to another either group company or third party, and that may not have the same level of security, which poses its risks, which may pose its own risk in relation to data breach. Location of data is obviously important, and you should also deal with individual rights. You should look at things like, did we inform data subject that we would be able to transfer data to third parties or intra-group, because your data may be moved to a country which is not necessarily a country of your liking. So those are things that you have to consider more than you had to under the currently existing framework. Then just a word about the transfer of data outside of the EU. We all know that we currently have the shield in place, but I would also like to warn that the shield is discussed heavily. And the working group party, the Article 29 working group party is of the opinion that the essential equivalent level of protection which is afforded to the US citizens is not afforded by the shields. There is also a long-standing position that massive and indiscriminate surveillance of individuals is not proportional or strictly necessary under the EU rules. And still, this is well, this is possible by U.S. government. So that it may well be that this will become an issue again once a citizen in the EU will bring this to court.
And this is the privacy shield, yes.
This is the privacy shield, yes, yes. Moving on to the next slide. Just wanted to say a few words about the data processors because their responsibility has increased, and the number of obligations applied directly to data processors which have to do with data security and records of data processing. The data processor used to be able to say, well, we apply the security measures and levels that we are asked to by the data controller. And we record data, but we do it for the data controller. Now the data processor has its own responsibility and also has to be able to show to data subjects what they're doing. Additional requirements for data processing contracts have to do with assistance with data subject requests. who's going to respond to those. The data subject can turn to a data processor directly, and the data processor cannot say anymore you have to go to the data controller. Also, return and deletion of personal data may become an issue, and audit rights. Now, the other thing we just touched upon that is liability issues vis-a-vis data subjects, I should say. There is a risk of double jeopardy, and the joint and several liability brings larger risks for data processors. I have to say, though, that the joint and several liability is only in respect of the part of the data processors of the activities. But still, that is something that can be discussed heavily, of course, once in litigation. And data processors need to adopt risk mitigating clauses in data processing agreements, and things that should be considered would be responsibility for the lawfulness of processing, guarantees from the data controller that the data are collected in a lawful manner. Also insurance, of course. Data processors have to look at their insurance. Data processors should think about limiting liability or recovery actions to data controllers, indemnifications. And one other aspect is how to defend the litigation. Are you going to take your own route? Are you going to work together with the data controller? It obviously all depends on the circumstances, but those are things that data processors must start considering. I can move on to the next slide, please. One ground for data processing under the GDPR, which was already in place under the directive, is a legitimate interest. And in addition to consent and execution of a contract, this is probably the most used ground to justify data processing, although I must say it does depend a little per member state, because some member states at this point in time say, no, consent is the #1 justification. There is a new requirement, though, and that is that controllers must maintain a record of the assessment of legitimate interest, which should demonstrate to the proper consideration of the rights and freedoms of data subjects. It basically means that you should not go further with your data processing activities than that the legitimate interest requires. And an additional measure or an additional requirement is that data controllers must adopt the legitimate interest and an explanation of why there is a legitimate interest in the information notices. We can move on to the next slide. I just want to say a few things about consent under the GDPR. It's predominantly the same as it is under the directive as we currently have it, so it should already be freely given, should be specific, informed, and unambiguous. However, the concept of freely given is further defined, and it's invalid. Any consent is invalid in case of coercion. This means that a provision of a service may not be conditional on a consent that is not necessary for the performance of a contract. And very important in employment relationships, for instance, is the significant imbalance of power. This means that if the data subject is in some way depending on the data controller, consent is not the good concept. So you should be able to rely on, I don't know, execution of contract very often, or you should be able to rely on a justified reason, legitimate interest, any of the other grounds. So consent is not as free as it was. Now, unambiguous has not changed. And informed consent means that you have to explain the purposes for the processing, nature of the data, recipients again, and the burden of proof for the above is on the data controller. Consent is also a bit of a difficult concept because it can also be withdrawn at any time, which means that you immediately lose your justification ground. And the GDPR now specifies that consent should be withdrawn in the same way as consent was given. So what you sometimes see is that the consent can be given by ticking a box, but that if you want to withdraw consent, is that you have to send a registered letter. That's no longer possible. Moving on to the next slide.
We have a question if data controllers and processors will be given a timeline to comply, or must the controllers and processors be in compliance by May 2018?
Yes, it's the latter, because the whole reason for giving a 2-year term is allowing companies to be able to prepare. So they must be in compliance by that time.
Very good, thank you.
Okay, now all of this means, the GDPR means that, and the aim of the GDPR is that there is the creation of a culture of data protection and security within companies and organizations. And we say that a vital part of putting in place a comprehensive privacy framework is internal training and awareness. Very often data breaches happen or non-compliances happen because people are just not aware. They're just not aware that they should not open a cupboard with information, so to speak. They're just not aware of the risks of bringing their BlackBerry to the US, which basically means that you're exporting data to an ex-EU member state. And it is just very important in order to prevent and detect data incidents, and also for IT departments to be aware of cybersecurity incidents and the awareness to report those, which is again where a data breach protocol comes in. Now, this is not just important for those who will provide access to personal data, but also for those who receive access to personal data. And the issue is that if you receive personal data, maybe you cannot simply say anymore, well, I've asked if he's compliant in sending me those data. No, you have your own assessment to do. Moving to the next slide, which I think is also my last slide. Yeah. The pitfalls. I think it has become clear that there is no real full harmonization, even though it's a large improvement as opposed to the situation that we now have. But the lack of harmonization lies probably in the sanctioning and how the national supervisory authorities will be dealing with sanctioning, when they will apply fines and the hike of fines. There are also specific examples, one of which is employment law. Others are issues that have to do with national security, healthcare, and some other obvious ones. Then there is the interpretation of the GDPR by the member states. So if you have a case against a national supervisory authority, you don't agree with a penalty decision or another sanctioning, you would have to go to court, and then the national court is going to interpret the GDPR. And that is not necessarily the same interpretation as a German court would have. Applications of fines and the factors considered, just talked about that. Also that the privacy shield is not part of the GDPR and it may be challenged. So we just don't know how long it's going to hold. And then another pitfall is that when companies rely on consent instead of another justification ground, they cannot switch back once consent is withdrawn. So if you have another justification ground, it is very often better to use it instead of consent, because it does not give you the level of security that it seems to have. And that's what I wanted to share.
Well, thank you. We have a couple of questions. One is just administrative about the slides. They're fantastic slides, and yes, they will be available on the ACEDS website. And we have a question about if you see a sense of urgency within the Dutch and European community and companies to get ready for May of 2018.
Yeah, what we get, what I see in advisory work is we see a lot of people preparing data breach protocols. Now that may be because in my jurisdiction that's already enacted, so the risk is already there. But we also see people drafting protocols to outline the measures that they have taken. And I have seen from, for instance, hospitals. They are starting to draft template data processing agreements, and other companies do that too. We also see that a lot of companies are now trying to hire data protection officers. So a lot is happening, but the thing that nobody seems to be really doing, and it's also the most difficult task, is to really look at what data do we have and what grounds of justification do we have to process these data. Who is holding it? Who's looking into it? What data do we have? And why do we have it? That is a question, and I know it's the most difficult question, but that is the basic question that should be addressed.
And then a question about data that's used in litigation. Is that generally covered under the legitimate interest or under the consent requirement?
That depends a little on whose data you're talking about. Very often it will be covered by legitimate interest, but not necessarily. If you want to use data from somebody else just to prove your point, to substantiate your position, you probably need to ask that person. I cannot give a general rule, but legitimate interest is a ground which justifies using information, but also not erasing information, as I said earlier on.
Very, very good. Very good. So we do have some external resources that are on the screen now, and you'll be able to download you'll be able to have the slides with that particular link. And then we're shifting over to why automation is necessary and needed to comply with the GDPR, and we'll have Jan.
Yeah, Mary. Can you hear me?
I can. Very
good. Thank you. Yeah, thank you also, Machteld, for your presentation. Very interesting. I also have a couple of questions, but I'll save them for later. It's going to be a big change, that's for sure. What I would like to talk about today, if you go to the next slide, Mary, please, is why automation is needed. Now, of course, we all know there are huge volumes of enterprise data, and exactly what Machteld touched on, corporations, enterprises often do not know what they have and why they keep it and what's the purpose and what they're doing with it. So this is really one of the first tasks that organizations should think of when they're looking into the challenges of the GDPR, and then in particular of personally identifiable information, or as we call it, PII. Having control over the data is very important. If you have no control, if you have no clue what is where, then this can be a very costly and immense risk in case of being investigated by the regulatory authorities or in case of litigation. If you don't know where your data is and it's not properly protected, or the data is not encrypted according to certain standards, then it's also more sensitive to being hacked or being leaked. So it's very important to store this type of information on highly secure servers and not on all kinds of other storage devices that often float around in organizations. Now, PII is not only in text, it's not only in structured databases, it's not only in email. A lot of the text in the GDPR is about structured data. One of the interesting things that I noticed is that people have to request to get a disclosure of all the data that's available on them in a structured machine-readable format. So what happens if that information is in email? If you have social security numbers or European identifiable numbers or other information in email, should you then retype it, or you know, there's probably going to be a lot of questions there that need to be answered. And there's a lot of stuff also in metadata, in videos, in images. So we need to think about that. And of course, as Machteld also touched, protected health information, PHI, can also be all over the place. A great example is a lot of the PHI and PII that actually was present in the Enron data set, which has been used by a lot of vendors in the eDiscovery space for demo purposes. Okay, next slide, please, Mary. Now, so what we're trying to discuss here today is how can we go from this privacy protection to safe disclosure, and this is one of the more interesting use cases where data has to be disclosed to other parties, and I will discuss a couple of those use cases. This is kind of a different use case from the problem to assess and detect where information that needs to be secured or maybe erased, where it's located. That's typically a search problem where you need to crawl all your data sets and then search for certain words or patterns or certain information. But there are also use cases where this information has to be reviewed and then disclosed to maybe a regulator in another country. This is where the process of redaction and anonymization is very important and will become much more important. And we already see this happening from very large disclosures from countries where there is already a strong data protection culture, like Germany and France, for instance, two regulators in the US, where all of the PII has to be redacted before the data is disclosed to a US regulator, which is an extremely time-consuming but also very expensive process. And you can imagine that if you are a US company and you do have subsidiaries in Europe and you do need to get data from these subsidiaries to the US or to a regulatory agency, or for instance, if you're doing a foreign corruption practice investigation just for audit purposes after a merger, then that can be a big problem. Okay, the use cases. You already put them there, Mary, thank you. So a very strong use case is data disclosures from the European Union to US regulators. You can also have data disclosures from the US to the US in case of international litigation or arbitration. And then you have to just redact all of the PII, identify and redact, and then blacken it, all the PII, PHI, and all the other information that is protected under these new European regulations. This is also a problem you see in the case of M&A. When you want to disclose employment agreements, for instance, in part of a virtual data room, as part of a whole M&A process, you have to redact it. You cannot just show all this personal information to everybody looking in the data room, especially not from outside of the European Union. And then, of course, as Machteld said, there's the cybersecurity, the post-data breach investigations that have to figure out whose data has leaked, whose information has been leaked, and who's involved, and who's affected, and then warn those people within the 72 hours. Okay, next slide, please. Now, there's technology, and there's some great technology available to do this type of work, and we've been working with this type of technology at ZyLAB for a long time. One of the first things we've been doing for actually quite some time now is using text mining technology, where we can find certain patterns or also semantic categories as individual names, company names, organizational names, but also email addresses, Social Security numbers, license plates, phone numbers, bank account numbers, credit card numbers, you name it. What we can do with text mining is not only identify and extract this information to use it for better searching or reporting, but of course, if we know where this information is in a file, we can also redact it. And we can even assign a reason why it has been redacted. What is the exemption code? What is the rule that we use for this redaction, and burn that in. Now, we've taken this a little bit further in the last couple of months, where we can also do automatic anonymization. And what we can do is we can replace names like Mr. Smith by Mr. A, and use pseudonyms to replace these type of things. And this is sometimes what's requested by regulators, that they do not want just all the names to be redacted, but they want these names to be replaced with a certain alias. And this is even more time consuming than manual redaction. And this is something which technology can really help you with. You know, it's of course there are many different Mr. Smiths. Then it's hard to distinguish them from each other. But a lot of the work, if the computer can only do 60 or 70% of the anonymization properly, and the rest has just to be reviewed, it already takes a huge amount of out of the cost and the risk and the time delay of such a process. Important is also, you know, in the European Union we speak 26 languages. It's very different from the US market. So you need to be able to determine whether certain information is disclosed in one of these 26 major languages. Actually, there's many more. Some countries speak even more different dialects and languages. It's important to recognize those different languages, if possible to translate it, and then to assess whether this contains PII or PHI. Audio search becoming more and more important. We're going to talk a little bit about that. And then the cloud, Microsoft Azure. A lot of this data is in cloud environments, and Microsoft Azure has a couple of huge benefits over some of the other cloud solutions, especially because Microsoft guarantees where your servers are, which jurisdictions they are, and that means that you can use Microsoft Azure for processing of a lot of this data, or anonymization or redacting of this information within the jurisdiction, and then there's huge benefits to that. Next slide, please. So here's just, you know, a couple of the things that you need to worry about. You know, certain dates directly related to individual, birth dates or other dates, phone numbers, email addresses, we all know. This is just a small list. If you look at what has been declared PII and PHI, the general terminology is very vague, and there's even indirect identifiers can be considered PHI. So you need to go further than just search or what we call regular expressions. You really need to look at how the language is used and what the patterns are and the relations are to actually do a good job at this process. Next slide, please, Mary. Here's some examples of machine translation. Everybody's familiar with this. Google Translate, Bing Translate. What we've done is we've integrated this in our platform. So if you have a language, data in just any language, we can translate it. Either by using Google Translate and Bing, but then there's always the risk that they keep a copy of that translation on their servers. We also have software that runs locally, which does not require any disclosure of data to any of these other parties. And then you can translate, I think it's up to 5,000 pages an hour per core. So this is really, really fast technology. It's highly accurate. It's not legally submissible, but the quality of the translation is more than good enough to understand what's there. Next slide, Mary. Thank you. Audio. This has been in our software for quite some time already. It's our ability to directly search sound files and the sound component of a video file for keywords and look for certain kind of words and names and numbers, and this will also be allow us to identify PII and PHI in these type of files. The next one, please, Mary. So the kind of technology that can be used to protect data when it has to be disclosed can be categorized in kind of three different phases. First is the automated bulk redaction. So identify where all the data is that has to be redacted, redact it, and then in the second use case, you're going to replace certain names or company names or individual names with certain pseudonyms, aliases. And then very important, before you disclose it, you have to do another quality control. That's where we run another attempt of text mining over the whole data to see and try to make sure that we're not missing any phone numbers or names or other numbers that have been in the process. I got some screenshots there. You have to blow up your screen a little bit if you want to see it. This is actually some email. It's one of the emails from the Enron collection that we found. And we've redacted names here, email names, and we've also indicated reasons why we have redacted. So as you can see, they're all redacted because it's GDPR PII or GDPR PHI. You go to the next slide, we've taken it one step further. And that's where you can actually see that this information comes directly from the same interface that we also use for the legal review. So in an arbitration case or litigation case, or when you're looking at data for regulators, it's the same platform, so you don't have to upload and download it and disclose the data to different platforms. So you do all this type of work in here. And then if you go to the next slide, we've taken it one step further where we actually have replaced names by numbers, and each number is an alias for somebody, and then this can then be disclosed to regulators in the US, and they will accept this instead of seeing all the names, and that's for a certain period when they're reviewing data. Of course, they will be interested in the names later, but then they must have some clear evidence or indication that that individual did something wrong in the jurisdictions of the United States. Okay, so the next slide, we've put it here in a graph. So there's the intake, the processing, the auto-redaction, the quality control. On that auto-redaction and pseudonyms. Next thing what we do is we typically generate a production, a draft production. And then this draft production is also then ran against text mining technology with a very high recall. And what we do is that we try to find whatever possible name or number still in there, and make sure that everybody agrees that these numbers don't need to be redacted, and then we can do the final production. And this is a very safe process where there is still manual quality control needed, there's sampling needed, but when you have a manual redaction process, people also forget things. So humans also make errors, and in general, computers are more accurate than humans, but yeah, we do need to have some kind of sampling process and review, which has to be done by paralegals or lawyers to make sure that the whole process and the whole disclosure is defensible.
Yeah, we have a question about whether the replacement of names by numbers, with the aliases, is that happening in text format or in TIFF format?
Well, what you see, if you go back to the previous slide, it's actually text that's burned in on top of the redaction. And then if you here we've chosen to do it in white. But if you use proper OCR, typically you then do a TIFF production or PDF production or bitmap production to the regulator. But then with the right OCR engine, you can read them again and turn them into numbers. Is that the question, or?
Yeah, I think the question is it in native format or TIFF format that you're able to make these redactions?
This is a TIFF view of the native format. And but you can always go, but we don't do redactions in the native files. That's impossible. You have to do it in a TIFF file. Otherwise, there's always some kind of hidden layer underneath that can be disclosed in this whole process. Even PDF is a risk, so you have to do it in a bitmap. Yeah.
And then another question along the same lines, inquiring around redaction inside audio.
Yeah, that's a good question, and we're still thinking about that. How can we add the beeps? And well, that's a very interesting part of where we're looking at. And then the other thing which is interesting is to not just redact these audio files and video files, but when you disclose them, you can put in a beep, but then you could also put in another voice saying Mr. A. I don't know. We haven't figured that all out. But it's one of the things, at least by detecting it, we can find these audio files right now, which contain sensitive information, and then before disclosing it, there's we're still waiting for the right technology to do that.
Very good. Thanks, John.
Yeah, okay, good. Then the next one on Azure. Azure is, like I said, a very interesting platform because it guarantees that the servers are in certain jurisdictions. So if you have PII in Germany or France, and you need to process it, or you need to redact it, one of the things that you can do in Azure, and this also is related to data, for instance, which is in 365, Microsoft Office 365 in SharePoint or in OneDrive or in emails. What we can do is we can actually collect and process and redact all that information in a facility very close to the servers of 365 in an Azure environment, which is in the jurisdiction of that particular country. And then in Azure, you can also very easily spin on additional machines. So if you need to do a lot of processing and redacting and translation in a very short time period, you just throw in like 10s or 20s or 30 machines or very high performance machines. Once you're done, you just spin them down and you no longer pay for them. And that gives you the ability to do these type of things very, very cost effectively. And then only when the data is disclosed to the regulator, you actually produce it to TIFF and you disclose it to the regulator and take it out of the Azure environment into the jurisdiction where it needs to be disclosed to. So Azure is really a help. So you don't need to set up servers and special hardware in certain facilities or on premises, but you can just do anything from the Azure environment. Okay, that was it for me. We have some great e-books, they're called these days, where we actually go through this whole process a bit more, and we also show the screenshots in more detail, and we explain it. And if you send an email to Annalore, she will send you a copy.
Fantastic. And I have a couple of questions. One is for Machteld. What would be the top 2 things companies should do to prepare and get ready for the GDPR?
Describe their technical measures and everything else that they have in place to protect data. And the other thing I would say is make sure that your data processing activities have a sufficient legal basis. So review the data that you hold and review the basis for which you hold it.
And then your first suggestion was, I think, to get very familiar with the security protocols and how data is safeguarded within your organization?
Yeah. Yes, and you have to describe it. So you have to be able to show the regulators what you're doing to protect data. Now, what you often see is that people have all kinds of, measures in place, which go from locking the door to heavy IT systems, but nobody has a full overview. And that is what you need to be able to provide as of May 2018.
So hopefully there are some templates by that time, right?
Yeah.
Lock your door.
Indeed. Indeed. And then another question, I think, Jan, this is for you, I believe, the change related to the M&A use, like if you could contrast current practice against what you would envision once GDPR is in full effect?
Well, this is already in full effect right now. This is already in fact right now in Germany and France, so this is already happening, and even in other European jurisdictions. So, especially employment agreements and illness reporting and other information that's highly sensitive. That's where it's already happening. So, to answer your question.
Oh, I guess so. I guess so. Yeah. So what you're saying is there is no waiting; it's already here. So these practices that you've been showing us, say the redaction, the anonymization, those are things that should be happening right now.
Yeah, yeah. Well, it is already happening. It's what we see in the case of M&A, especially when the data room is prepared and when all the information is collected. That's where redaction and anonymization is part of the process before the data can be disclosed to other parties in the data room.
Very good. Very good. We had another question about having the slides available, and yes, the slides will be available. And there was a lovely suggestion to send out a link to registrants, and we'll make sure that we do that as well.
Yeah.
Let's see. I see no more questions here. Jan, you had mentioned you had a question.
No, all my questions are answered. So you asked all of them. So I have no more questions.
All right. Well, if we have no more questions, I want to thank Machteld and Jan. Thank you so much for a very informative webinar for our members, and thank you all for attending. I have greetings and nice day from the island of Puerto Rico, so we have quite an international audience and participation here. So thank you very much, and we'll close out the webinar with a call that if you want the ebook, request your copy at Annelore, ANNELORE.Vanderlint, VANDERLINT at ZyLAB, ZYLAB.com. I'm spelling that out for those of you who only do the audio. So thank you all and have a wonderful day.
Thank you all.
Thank you.
Bye-bye.